Breaking news for immigrant visa applicants. On August 21, 2026, U.S. District Judge Jeanette A. Vargas issued a major ruling in Catholic Legal Immigration Network versus Rubio. The court held that the State Department's blanket policy pausing immigrant visa issuance for nationals of 75 countries was unlawful and ordered the challenged policy vacated. That word, vacated, is the key word in this entire update. It means the court did not simply create an exception for one family. The court set aside the policy itself, but there is also an important warning from the start. This does not mean every immigrant visa is automatically approved. It does not erase every other immigration restriction, and implementation at embassies may take time. In this video, I will explain what the ruling actually says, who is affected, what happens to cases that were refused under the pause, the difference between this 75-country policy and the separate 39-country restrictions, and what applicants should do next. First, what exactly was the 75-country pause? The State Department announced that, effective January 21, 2026, it would pause immigrant visa issuance to nationals of 75 listed countries while reviewing screening and vetting policies connected to public benefits reliance and the public charge ground of inadmissibility. The official State Department page made an important distinction. Applicants from affected countries could still submit applications, could still attend immigrant visa interviews, and interviews could still be scheduled, but issuance of the immigrant visa itself was paused. The list included countries across Asia, Africa, Europe, Latin America, the Caribbean, and the Middle East. It included Nepal, Bangladesh, Pakistan, Bhutan, Thailand, Brazil, Colombia, Ghana, Nigeria, Jamaica, Albania, and many others. This was therefore a very broad policy with consequences for family-based, employment-based, and other immigrant visa applicants processing through U.S. consulates abroad. The next point is critical because the word visa is often used too broadly online. This particular 75-country pause was specifically about immigrant visa issuance. The State Department's own frequently asked questions said that tourist visas were not affected by this specific pause because tourist visas are non-immigrant visas. Student visas, exchange visas, and other non-immigrant categories were also outside this particular 75-country immigrant visa issuance policy. Although they could be affected by other rules or country-specific restrictions, the State Department also said that valid immigrant visas already issued were not revoked by this guidance. Dual nationals applying with a valid passport of a country not on the 75-country list were exempt from this pause. Adoption cases had a possible exception pathway as well. So when you hear the headline that the 75-country visa pause has been vacated, understand the exact scope. It is about this specific State Department immigrant visa issuance policy. Now let us explain the legal word everyone is talking about. Vacated. In administrative law, when a federal court vacates an agency policy, the court sets that policy aside. This is different from an order that only protects a few named plaintiffs. Bloomberg Law reported that Judge Vargas concluded the policy was unlawful and had to be vacated under the Administrative Procedure Act. That is why this ruling is much bigger than some of the earlier case-specific victories. The practical theory is that consular officers should no longer rely on the invalidated blanket pause as the reason to stop issuance. Instead, each immigrant visa case must go back to the normal legal framework and be evaluated on its own facts. But a court order and real-world embassy operations are not always synchronized instantly. The State Department may need to issue instructions to posts, update internal systems, communicate with consular officers, and decide whether to appeal or seek a stay. Why did the court find the policy unlawful? At the center of the dispute was the relationship between Congress's immigration law, the authority of the Secretary of State, and the role of individual consular officers. The blanket policy effectively predetermined that immigrant visas for nationals of the 75 countries would not be issued under the pause, rather than allowing the normal individualized adjudication to reach a lawful result. Bloomberg Law reported that the court concluded the suspension violated federal immigration law and exceeded Secretary Marco Rubio's statutory authority. The broader legal challenge argued that the government cannot take the public charge concept and transform it into a nationality-wide automatic stop when the statute requires an individualized determination. The judge therefore treated this not as a routine disagreement over one consular officer's decision, but as a challenge to a general State Department policy that governed thousands of cases. The public charge issue deserves its own explanation. U.S. immigration law has long included a public charge ground of inadmissibility. In simple language, immigration officers can consider consider whether an applicant is likely to become primarily dependent on government support. Using the legal standards and evidence applicable to that case, factors can include financial sponsorship, household circumstances, and other information required by law and policy. What the 75-country clause did was different. It connected the issuance stop to nationality across a very large list of countries while the government reviewed its approach. The plaintiffs argued that this displaced the individualized role of consular officers. The court agreed that the policy could not lawfully operate as a blanket substitute for case-by-case adjudication, so the ruling does not eliminate public charge law. It means public charge must be handled through lawful individualized adjudication rather than by simply using the 75-country clause as the answer. This ruling also did not emerge in isolation. During 2026, other applicants challenged the same or related State Department clause in federal court. One important case was Demura Gomez versus Rubio in the District of Columbia. On July 31st, Judge Amit Mehta ruled that the public charge-based visa freeze was unlawful as applied in that case and ordered the family to receive a new adjudication within a set period. That decision was significant, but it was case-specific and did not itself wipe out the policy for everyone. Other lawsuits also produced relief for individual applicants. Those earlier decisions increased the legal pressure on the government's theory. The August 21st ruling in Clinic versus Rubio is therefore especially important because the court vacated the challenged policy rather than merely directing relief for one family. That is why immigration lawyers and affected applicants reacted so strongly to this decision. Many affected applicants received a refusal or administrative processing notice under Section 221G while their immigrant visa could not be issued because of the clause. What happens to those cases now? The most important point is that a prior 221G notice does not automatically become an issued visa simply because the policy has been vacated. A consular post may need to reopen or resume the case, confirm whether documents are still current, complete security or administrative checks, review medical validity, verify financial evidence, and make an individual eligibility determination. Some applicants may be contacted by the embassy. Others may see movement in the consular electronic application center before they receive any mail. Still others may need new documents because time has passed. The safest expectation is not instant approval, but a return to case-by-case processing once the State Department implements the court ruling. If you already have an immigrant visa interview scheduled, do not cancel it just because of this news. Follow the appointment instructions from your embassy or consulate. Bring the required civil documents, financial sponsorship evidence, police certificates, medical examination results, and any updated documents requested for your category. The old State Department guidance said interviews could continue even while issuance was paused, so many cases may already be close to completion. After the court's ruling, an interview could become even more important because the consular officer may be able to complete the individual adjudication once new implementation instructions are in place. Do not assume that a YouTube video, a social media post, or even a court headline replaces the instructions on your own case. Your embassy's communication and your case status remain the practical sources you must follow. What if your interview already happened and the only barrier was the 75-country clause? This group may be positioned to benefit most directly from the ruling because the policy that created that blanket barrier has now been set aside by the district court. But again, the word benefit does not mean guaranteed issuance. The embassy can still identify another lawful ground of inadmissibility, request missing documents, continue administrative processing, require an updated medical examination, or wait for a visa number if your category is numerically limited. If your refusal sheet or embassy communication clearly referenced the clause, keep copies of those documents. Keep your case number, petitioner information, and contact details organized. If there is no movement after official implementation begins, you may consider contacting the embassy through its designated channel or consulting a qualified U.S. immigration attorney about your specific situation. For viewers in Nepal, this is a particularly important development. Nepal was explicitly included on the State Department's 75-country list. That meant Nepali immigrant visa applicants could attend interviews but could be blocked from visa issuance under this specific policy. The August 21st ruling removes the legal basis of that challenged blanket clause at the district court level. Nepal is also important when we compare this policy with the separate presidential proclamation restrictions. Nepal is not listed among the 39 countries covered by Presidential Proclamation 10998, so a Nepali applicant who was affected only by the 75-country immigrant visa clause is in a very different position from an applicant who is also subject to the separate 39-country proclamation. That distinction can completely change how the ruling affects a real case. Let us make that distinction very clear. The 75-country pause and the 39-country presidential proclamation are not the same policy. Presidential Proclamation 10998 took effect January 1, 2026, and fully or partially suspended visa issuance and entry for nationals of 39 countries, with specified exceptions and limitations. The State Department's official page lists 19 countries under full suspension, another 19 under partial suspension, and a separate immigrant visa restriction for Turkmenistan. Some countries appear on both lists. If a person is subject to the proclamation, vacating the 75-country public charge pause does not automatically erase the separate proclamation. This is one of the biggest reasons the headline "All visa bans are over" would be misleading. The August 21st ruling is major, but it is major within the scope of the policy the judge actually reviewed and vacated. The question almost everyone wants answered is, will visas start printing immediately? The most accurate answer, as of August 22nd, is that we should watch implementation closely rather than promise an exact timeline. When checked today, the State Department's public visa news page still displayed the February guidance announcing the 75-country pause. It had not yet posted a new public notice replacing that page with detailed instructions about Judge Vargas's ruling. That does not cancel the court's order. It simply means the public-facing agency guidance may lag behind the legal decision. Internally, the State Department may need to send a cable or other instructions to consular posts. Embassies may need time to identify affected cases. Some posts may move faster than others, so applicants should be hopeful, but they should also be careful about claims that every embassy will resume issuance on exactly the same day. Another major question is whether the government can appeal. Yes, a federal district court ruling can be appealed to the appropriate federal court of appeals. The government can also ask for a stay, which is a request to temporarily suspend the effect of the ruling while an appeal is considered. Whether a stay would be granted depends on legal standards and the decisions of the courts involved. The existence of a possible appeal does not mean a stay has automatically been entered. That is why viewers should separate three different things. The district court has issued its ruling. The government may choose to appeal, and a higher court could later change, limit, pause, or affirm what the district court did. Because this story is developing quickly, the legal status can change after a video is published. Always check the date of any immigration update you watch. So what should an affected applicant do today? First, do not withdraw or abandon your immigrant visa case because of old pause guidance. Second, keep monitoring your embassy or consulate, your registered email address, and your online case status. Third, make sure your documents are ready. Passports should be valid, civil documents should be available, financial sponsorship documents should be current, and medical examinations may need renewal if they have expired. Fourth, keep copies of any 221G refusal sheet or email that connected your case to the 75-country pause. Fifth, if you have an interview scheduled, follow the official appointment instructions. Sixth, if your case has unusual complications, a deadline, a diversity visa expiration issue, age-out concerns, or another restriction, speak with a qualified immigration lawyer rather than relying only on general online information. Before we finish, here is a simple list of what this ruling does not do. It does not guarantee an immigrant visa to every applicant from the 75 countries. It does not eliminate the public charge ground from U.S. immigration law. It does not erase security screening, criminal or fraud-related grounds of inadmissibility, medical requirements, documentary requirements, or numerical visa limits. It does not automatically cancel Presidential Proclamation 10998 or other independent immigration restrictions, and it does not mean every consular post will update every case instantly. What the ruling does is extremely important but more precise. It sets aside the challenged State Department policy that used the 75-country pause to stop immigrant visa issuance and restores the need for lawful individual adjudication rather than reliance on that blanket policy. Here is the bottom line. On August 21, 2026, Judge Janet A. Vargas of the U.S. District Court for the Southern District of New York ruled against the State Department's 75-country immigrant visa issuance pause in Clinic versus Rubio and ordered the policy vacated. Bloomberg Law reported the court's conclusion that the policy was unlawful and exceeded the Secretary of State's statutory authority. The State Department's own earlier guidance confirms that the pause had applied to immigrant visa issuance for nationals of 75 countries, including Nepal, while tourist visas were outside that specific policy. For applicants affected only by this pause, the ruling is a major positive development, but cases still require individual adjudication. Other restrictions can still apply, and implementation plus any appeal or stay must be watched closely. For verification, use primary and reputable sources. The first is the federal court docket in Catholic Legal Immigration Network versus Rubio, case number 26 Civil 858 in the Southern District of New York, with the August 21st opinion and order identified as document 83. The second is the U.S. Department of State page titled Immigrant Visa Processing Updates for Nationalities at High Risk of U.S. Public Benefits Reliance, last updated February 2, 2026. The third is the State Department's separate guidance on Presidential Proclamation 10998 for the 39 country restrictions. Reputable legal reporting, including Bloomberg Law, has also reported Judge Vargas's ruling. This video is educational information, not legal advice, and immigration developments can change quickly. Check official sources before making travel, financial, or legal decisions. If this update helped you, share it with someone waiting on an immigrant visa and follow for verified updates.